All right. It will be made a part of the record for all purposes. The agreement here is whatever sentence shall not exceed a cap of 10 years confinement in prison. So this is a deadly weapon used. So our options here would be deferred or unadjudicated probation up to 10 years in league, or confinement of no less than 2 nor more than 10 years confinement in prison. Regular probation is not an option in this case. Is that all? Does everybody agree, since a deadly weapon, namely a knife, was alleged to have been used in the commission of this offense? Okay, go ahead for the defense, Mr. Dusler.
Your Honor, he's asking for deferred adjudication probation. The pre-sentence report pretty much sets out what happened according to him. It was a stabbing. He does admit responsibility for the stabbing, but he's not saying that it was justified, but he's saying that he felt like that he didn't really have much other choice. The victim and he had been hanging around the Salvation Army for quite a while, and he mentioned that this victim had threatened to stab him and had been bothering him for many, many days prior to this incident. In fact, Mr. Campbell even went to the Beaumont Police Station multiple times to report that.
Who did you talk to over there?
Detective Armstrong.
Armstrong? What did he say?
He told me to protect myself. He couldn't do anything about it. He just told me to protect myself.
Okay. Looks like there's video of this.
Yeah, he doesn't dispute that it happened. He just felt like that when the detective advised him to protect himself at all costs, that he felt like that was what he needed to do to protect himself. He's got a history. Many of it was a long time ago, 20 years or more ago, when he was a teenager. He feels like that he could successfully complete probation, and that even though sometimes these things are not justified in his mind, he felt like this was the best thing for him to do at the time. He regrets that it happened, but he would like the court to give him an opportunity on probation to prove that nothing like this would happen again. That's said pretty well. Okay.
Let me look at, I'm looking at the pre-sentence report, Mr. Dusler, and also Mr. Campbell, make sure that we got all this. It looks like it dates back to 1993, so that's 32 years. And it looks like in Pinellas County, Florida.
Yes, sir.
Correct. You were placed on 3 years deferred or unadjudicated probation for aggravated battery back in 94. Then that was revoked. And then you were placed on, looks like they found you guilty and placed you on regular probation thereafter in February of 95. Then that regular probation was revoked about 5 months later in July of 95, and you were sentenced to 1 year's confinement. And then finally, in 2019, you were convicted and sentenced to 13 months confinement for theft with 2 or more prior convictions. So I'm looking at, correct me if I'm wrong, everybody. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 felonies, convictions, including aggravated battery twice.
I believe that's correct, Your Honor.
And then the others are theft related, burglaries, crimes such as that nature. Okay. So your criminal history is bad. And let me ask you here, before I let the lawyers talk, according to this pre-sentence report, you, the victim was lying on the sidewalk when you approached him and suddenly stabbed him multiple times, saying, "See now, bitch," before running off. And they, later the police were able to figure out who you were and saw you walking northbound on Magnolia. You had changed your clothing. You were no longer wearing the same jacket and ball cap and backpack as had been observed earlier. And what you were wearing on the video that they looked at. And so they detained you. And then you stated he had been talking, well, vulgarity for weeks, is your explanation.
And right then he was too.
Yeah. Okay, you were taken to the Beaumont Police Department and you stated you were homeless, you slept near the Philadelphia church. You had called the police several times regarding people from Salvation Army who have harassed you,
Including him.
but nobody had ever physically assaulted you. You confronted the victim because he had been bothering you. You admitted stabbing him with a pocket knife, but claimed it was in self-defense. I had to protect myself. When asked if the other person had a weapon that you stabbed, you said you did not see any weapon, and that he was unarmed and sitting on the sidewalk. And your version essentially was the guy had threatened to stab you and had been bothering you for several days. Looks like that's okay. So I get a sense of what the defendant's contention is. So what says the parties?
He's asking for a verdict.
I know why. I mean, he's got a rich criminal history and a violent crime. And what about the circumstances of this case? I mean, the guy stabbed, the victim is stabbed, and he's lying on the ground. And words are not provocation enough under law. Somebody says bad things to you, they have to make some overt act to coincide with that, because people sometimes have bad taste and are reckless in their statements to others. But that's not enough to stab somebody and almost kill them. I mean, it has to be defending from aggression, but he's sitting on the sidewalk, or he's laying down on the sidewalk. What's all that about? How does the defense explain that away? I know it's not a defense, but what's good about it?
Well, there's nothing good about it. I obviously wasn't there, so I don't know what happened.
I know, I'm just reading the report like you do.
I'm reading the report as well. And
What's good for the defendant?
what he tells me is this was an overreaction. It was a foolish mistake at the time. He realizes in retrospect he shouldn't have done it. Most of his criminal history is 20 and 30 years ago. That's the reason why he's asking for a chance before this court. Pretty much everything, huh?
It been months. It wasn't just
Yeah.
days, just months.
Or he was just gonna,
I went to the police station about a month before this. Tried to get the police to do something about it.
but what were they supposed to, what do they
At
do?
least talk to him or something. I don't know.
But nonetheless, the law states that words are not enough for you to commit aggravated
That's what
assault.
he's been doing.
There has to be an overt act at the time to cause you to protect yourself. He's laying on the ground asleep, isn't he?
He was sitting down.
Sitting down. Okay. Did he have was he brandishing a knife or something? A weapon?
He was talking. He was
just speaking.
He was still speaking.
Okay, but
Yes, sir.
unfortunately, people who speak and use poor taste or even threatening, that's not enough to take something out and stab them under the law. Because unfortunately, people often say things they shouldn't say disrespectfully. That just doesn't give you the power to grab something and assault them with a stabbing instrument, which is capable of causing serious bodily injury or death. All right, what's they say?
Your Honor, given the fact that there was no provocation whatsoever, in this instance, he was unarmed. He was not fighting or making any sort of altercation. That coupled with all of, the history here and the evidence that every time he was given the chance on probation, it was then revoked later on. The state is asking for 10 years.
All right, go ahead, Mr. Campbell. Tell me what you need to tell me that helps me make my decision.
I don't know, I tried to resolve the issue. And I'm older now, so 20 years ago when I was on probation, I wasn't trying to do probation. But I can do probation now. I'm older. I need to set a foundation for myself some kind of way because I'm not gonna be able to work after a while. You know, I'm 50 now. And I think I can do it. You gave me to.
Okay. But what are we, I'm looking at, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9 convictions. Let me see. 10 convictions, right? Felonies and misdemeanors. Okay, so that's high, and that isn't helping you. And then here, the circumstances aren't good. This guy could have died, and he was just laying on the ground, and that's not a good thing either. But mistakes have consequences. You've been to prison or facilities at least 10 times in punishment of acts that you had committed.
Prison not helping. Put you in a mindset of protecting yourself all the time.
Yes, well, that statement isn't really good for you. It makes it sound like you've been to prison so many times, you're just plain dangerous now to be left out.
No.
That's what you're saying.
No.
I mean, that's not what you intend, but that's what it boils down to.
I'm harmless.
You're harmless?
Yes.
Well, I don't think the victim in this case thought that.
After what he put me through, I think.
Sir, he was laying on the ground. I mean, people shouldn't mistreat others and be disrespectful, but you don't stab them when they're just laying down.
Right.
But you have to defend yourself.
I think one of the big problems, that when I looked at this is that none of us really understand the dynamics in the homeless community. While, we could look at it and say it certainly wasn't justified. Their lifestyle and like I said, the dynamics of what goes on there, we can't really truly appreciate.
No, but they like all of us have to conform to the mandates of the law. And laying down, and you stab somebody who had said bad things to you in the past in poor taste. Poor taste is not a crime, unfortunately.
Your
It
Honor.
doesn't. We're talking about something that's life threatening here.
The homeless community is afforded the same elements of self-defense. However, I don't think that this was present here whatsoever.
No, I know it's clear it's not. It's just, what do we do here? And unfortunately, it's criminal history is so. What do you plan to do when all of this is behind you?
Work and stay out of trouble.
What do you do for a job? What are your job skills?
I'm confident.
A carpenter?
Yes.
Are you good at it?
I'm pretty good.
I'll be.
All
right.
I ran into a little money I can for fees and stuff. So I ended up getting a settlement.
You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And there will be an affirmative finding that a deadly weapon, a knife, was used in the commission of this offense. And I hope that you use more discretion. You have to defend yourself, but here, this was not the case under the law that fits your use of force that was capable of killing a person. You can't stab people when they're just laying down on the ground, not an immediate threat to you, but you do have to defend, you do need to defend yourself when they are. And this wasn't the case. Criminal history does not help you. It works against you. And there could have been probably some of these prior convictions could have been used to enhance this indictment, which weren't done in this case. So the court finds under these circumstances, this is the appropriate disposition. You understand what has happened today, sir?
Yes, sir.
Good luck to you. Thank you. That is all.
What we just witnessed in this courtroom is a textbook example of how self-defense claims collide with criminal history and how the law draws very sharp lines when it comes to the use of deadly force. Let's break this down carefully. First, the charge involved the use of a deadly weapon, a knife. That immediately changes the legal landscape. In Texas, an affirmative deadly weapon finding carries serious consequences. It limits eligibility for certain types of probation and affects parole eligibility. That's why the judge made it crystal clear at the beginning, regular probation was not even on the table. The only real options were deferred adjudication, capped at 10 years, or prison time between 2 and 10 years. Now consider the defendant's argument. He admitted the stabbing, there was no dispute about that. Surveillance video existed, he changed clothes afterward, he acknowledged using the knife. His defense wasn't denial, it was justification. He claimed the victim had harassed him for weeks, threatened him, and that he had gone to the police beforehand. According to him, a detective told him to protect yourself. That phrase became central to his mindset. But here's where the law steps in with precision. Under Texas self-defense statutes, verbal threats alone are not enough. The judge emphasized this repeatedly. For deadly force to be justified, there must be an immediate threat, an overt act suggesting imminent danger. In this case, the victim was sitting or possibly lying on the sidewalk, unarmed, no weapon brandished, no physical attack in progress. The judge's statement, "words are not enough," is legally accurate. Self-defense requires proportionality and immediacy. You cannot use force capable of causing serious bodily injury or death simply because someone insulted or previously threatened you. The law requires that the danger be present and unavoidable in that moment. Then there's the criminal history. This wasn't a first-time offender who snapped under pressure. The judge walked through a record spanning back to 1993, 10 felony convictions, including aggravated battery twice, multiple probations revoked, prior prison sentences. That history matters. In sentencing, judges evaluate not only the current offense, but patterns of behavior. And when probation has repeatedly failed in the past, it becomes much harder to argue that this time will be different. The state asked for the maximum, 10 years. That request was grounded in two factors: lack of legal provocation and repeated failures on supervision. The defense tried to humanize him. They emphasized age. He's now 50. They pointed out most violent history was decades old. They referenced the harsh realities of the homeless community, suggesting that outsiders don't fully grasp those social dynamics. That argument introduces an important social lens, but legally, it doesn't override statutory requirements for self-defense. And then came sentencing. 5 years. Not the maximum, not probation, not 10 years, 5. That tells us something significant. The judge acknowledged the seriousness, deadly weapon finding included, but she also chose not to impose the harshest possible penalty. She even noted prior convictions could have been used to enhance the indictment further, but weren't. That suggests the court viewed 5 years as a measured response, serious consequences, but not the statutory ceiling. This case underscores 3 critical legal lessons. Self-defense requires immediacy. Past threats don't justify present violence without an active threat. Criminal history weighs heavily at sentencing, especially repeated probation violations. Judges balance punishment and proportionality. 5 years reflects both accountability and restraint. Now here's the big question for you. Was 5 years fair? Should his past define his present? Or was the judge right that this crossed a line the law simply can't excuse? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.